Joint debt, the marital home, and bankruptcy traps in Utah divorce. In divorce, people often focus on who gets the house, who gets the car, and who is ordered to pay the credit card, things like that. And it makes sense, but it can also be dangerous, especially when bankruptcy enters the picture. A divorce decree can divide property and allocate debts between the spouses. It does not automatically remove a spouse's name from a mortgage, credit card, car loan, tax debt, business debt, or medical bill. It does not automatically bind third-party creditors. That gap between what the divorce decree says and does and what creditors can still do is where people get burned. Suppose the divorce decree orders your ex to pay a joint credit card. Your ex then files for bankruptcy. Your ex's personal liability to the credit card company may be reduced or discharged, but if your name is still on the account, the credit card company may still pursue you. My ex was ordered to pay it may be true, but it may not solve the creditor problem. Many divorce decrees include indemnification language. That usually means one spouse agrees to protect the other from a particular debt. That is useful and often necessary. But indemnification is not the same as creditor protection, or rather, protection against creditor claims. Indemnification gives you a claim against your ex. It does not necessarily stop the creditor from suing you, damaging your credit, collecting from you, or reporting missed payments. When possible, joint debts should be paid off, refinanced, transferred, closed, or otherwise resolved so that the non-responsible spouse is no longer contractually liable. The marital home is often the biggest problem. A decree may say one spouse keeps the home and refinances the mortgage, or that the home must be sold and the equity divided. But if one spouse files for bankruptcy before the home is sold, refinanced, or transferred, that spouse's interest in the home may become part of the bankruptcy estate. The bankruptcy trustee may examine value, mortgage balance, liens, exemptions, equity, and whether the property should be sold. A divorce judge may want the home awarded to one spouse, but the bankruptcy court may have something to say about the debtor's interest in the property. Refinancing provisions need teeth. A good decree should say how long a spouse has to refinance, what proof must be provided, what happens if refinancing is denied, whether the home must then be listed for sale, who chooses the real estate agent, who pays the mortgage while the house is listed, and what happens if someone refuses to sign sale documents. Vague drafting is dangerous, especially here. Husband pays the debt and wife keeps the house may sound simple, but if there are joint creditors, joint loans, joint signatures, or possible bankruptcy issues, simple language may create expensive problems later.